Welcome to Obsessed with Success, starring Russell Morgan.
Welcome back to Obsessed with Success. I'm Shameika Rhymes, and we're continuing our conversation with Alan Vaitzman, an associate at Morgan Legal Group, who focuses on probate and estate litigation. In this episode, we're focusing on what actually happens when estate matters turn into disputes and how these cases unfold over time. Hi, Alan.
Hi, Shameika. How are you?
Doing well. Welcome back.
Thank you. I'm excited to continue talking about all of these topics.
Well, Alan, what typically causes an estate matter to shift from administration into litigation?
So, administration is essentially litigation. It's just one of the branches of litigation in surrogate court. So, generally, there's three main branches. There's administration, there's probate, and then there's accounting. What triggers full-blown litigation is when people start to disagree. It's when people start contesting the fiduciary appointment of an individual, when they start to contest what this fiduciary possibly had done during her life, told the truth, treated the decedent with care and goodwill. It's when all of these issues start to arise that the judge says, okay, now papers really need to be submitted and we can't conference this anymore. That's when attorneys start really getting involved and do motion practice and a million conferences and a million emails, and it just takes so much time to get through everything. Truly, what pushes the case to full-blown litigation is the client's conduct. It's all about who is willing to agree to what and who is willing to take and lose what. If both sides are stubborn as mules, we're never going to get anywhere. And it's going to take 3 years to litigate, and it's going to be left up as a gamble to the judge and or jury, depending on where you are. If you're leaving this up to a judge or a jury, you might as well go to the casino and gamble. That's my best advice.
Yeah.
The best case scenario is for you to agree on terms certain so that you know exactly what you're getting, rather than leaving it up to people that have no idea who you are, and what you deserve.
What patterns do you tend to see in disputes once they become contested?
Generally, it's very petty things. Specifically when it's usually between a brother and a sister, and when one person decides to petition to become a fiduciary, the other person said, oh, but he lied to me about what he ate for dinner 3 years ago, so he's a liar and shouldn't be a fiduciary. And generally, that's how conflicts start. It's with something small that then snowballs into a much bigger issue, and usually it involves money. It's how much do I deserve? How much do you deserve? I cared for mom during the end of her life. You didn't. I bought her food. You didn't. These sort of things that people start to nitpick at, where, again, the attorneys are billing per hour. The clients are getting less and less out of their inheritance, and that's where conflicts really start. And it's not until the clients start to see a huge drop in their inheritance after all the legal bills that the clients are finally like, okay, let's come to the table.
Well, how do these cases usually develop over time after that initial conflict?
So the attorneys really step in, and not in a negative way. The attorneys in this field of law, they understand the power of stipulations and agreements. Our first instinct, as much as you see on these shows that you have these real bulldogs that fight, our first instinct truly is to see how we can resolve the issues. My first step would be to call opposing counsel, get their side of it, go back to my client, see what we can do in terms of a possible settlement offer ourselves, and then present that settlement offer to the other side. At least open the door to good faith negotiations, because if nobody opens the door, nothing ever gets done. And don't get me wrong, there's a lot of New York attorneys, specifically in New York, that don't like to settle because litigation makes money.
Oh.
It's just bad faith. They're, I don't want to say screwing their clients, but they are in a way, because they keep kicking the bucket down the road rather than just actually being an attorney, helping your client out, cutting issues off where they really truly don't need to be cut, and get your client the most amount of money that they can possibly get from this estate. There's been many times where I told clients, I'm going to do this and this for you for free. I'm not charging you, just because this is something that should have been done by a previous attorney,
Mhm.
or even things that need to happen now that simply out of our good ethical and moral backgrounds, we will not charge you for. It's just simply bad practice. And again, your clients appreciate it to the farthest extent that you can imagine. It's truly a blessing when you're working with a client that understands you, that is on board with you, and that truly listens to you.
What makes probate and estate litigation different from other types of litigation and how these cases progress?
So, touching on a little bit of what I previously mentioned,
Hmm.
it's the intimacy and how close you get with the people that you work with, not only in terms of judges and clerks, but with opposing counsels. You could be a Supreme Court litigator for years upon years and see different attorney in every case that you are dealing with. With estate law and trust and estate litigation, you're going to see the same faces over and over and over again. That is truly intimately different than anything else, because this is where you can truly build a name for you, your firm, and you get a lot of street credit
Hmm.
for that. You know, if you promise somebody something informally, because of who you are and because of the way that you practice, you will be given a lot of credence for that. And that goes for judges as well. If a judge knows what type of attorney you are and you promise to file something in 2 days or 3 days or 4 days, the judge will let you do it. And they'll give you that time based on your previous experience with them. If the judge knows that you're, a shady guy and you haven't been diligent in some of your cases, the judge will put strict requirements on you. So depending on your networking, your connections, how you work, with who you work, so on and so forth, it's a very different world than Supreme Court litigation or housing court or family law or anything like that.
Well, we kind of touched on this a little bit about, disputes once they become contested, but what misunderstandings tend to arise between family members once this dispute begins?
So one of the biggest disputes is how, especially in administration, I will say this, is how the estate is to be divvied up. What does a fiduciary do? What powers does this fiduciary have, and what are the rights of the other beneficiaries that are simply sitting on the sidelines and waiting for the fiduciary to go and do their job? Those misunderstandings truly snowball the cases a lot more than sometimes they really need to. We get calls from clients all the time, and these clients are simply beneficiaries of an estate where they believe that the fiduciary has the power to take and claim all the money in the estate just because they're the fiduciary.
Wow.
And we have to explain to them that no, in fact, this is not the case. The fiduciary has to be transparent, and there's laws that they have to follow in terms of divvying up the estate, 25, 25, 25, 25, or 50, 50, whatever the case is. These legal misunderstandings trigger so much anxiety in lay people's minds when they need to be involved in this field of law,
Mhm.
that should they consult with an attorney and a knowledgeable one, all of these fears can be put to bed. There will be a lot less conflicts. There will be a lot less unnecessary paperwork filed with the courts. And this is truly, I think, the biggest spark in this fire of what is trust and estate law litigation. It's just a misunderstanding of what people are entitled to and what other people can or cannot do after being appointed a fiduciary.
Well, what tends to complicate these cases beyond the legal issues themselves?
The assets that are within these estates, if you're dealing with a property that's in foreclosure, or there are certain funds that are with the New York Comptroller's office in the unclaimed funds pool, or there's for example, a wrongful death case that the decedent is a primary party of, and now the fiduciary needs to litigate that case. The assets of the estate are a big determining factor of how long everything will take. If this is something that needs to be litigated, if it's something that needs to be sold, essentially those are the main factors. The other biggest factor, one other one, is the amount of distributees and or heirs of the estate. If there's only one or two people that benefit,
Hmm.
you're only dealing with one or two people. But we've had some cases where there are 10, 15 distributees.
Wow.
We have to find them all, we have to serve them all, and they have to be a part of every single step along the way unless they default at some point. So the assets and the amount of interested parties that we're dealing with can really take a case from being closed out in about 8 to 9 months to being closed out in 20 years. I have a case right now with the file number from 2009. The,
Wow.
the case has been open with the New York Surrogate Court since 2009, and it's still not finished. So there is no end sometimes to some of these cases. Again, given the size of the estate, given the parties that you're dealing with,
Hmm.
it can take very, very quickly, or it can be a brutal 2 decades.
When it takes that long, I'm blown away by that. But when it takes that long, over time, people unfortunately pass away. So does that throw a kink in things as well? Because that's dropping the number of people that are involved.
Yeah, that's a huge problem. So when there's an interested party that is involved in any trust and estate litigation matter, or
Mm.
any matter for that effect, um, if that party passes away, the case that they're currently a part of gets put on pretty much an automatic stay. That case is stayed until a fiduciary is appointed to the person that passed away, and then that fiduciary comes into the shoes of the decedent, and then now the case can continue. But before there's a fiduciary appointed, this underlying case is stayed. Nothing can be done here because there's nobody to replace the guy that passed away, essentially.
Okay.
So, given the fact that there are certain administration and probate proceedings that take 1 to 2 years to complete, this underlying case here is stayed for 1 to 2 years. There's nothing you can do. And that throws a kink into this case. It also throws a kink into this case because now the parties here are trying to urge the court to hurry up with these proceedings in order to get back here. So it's a whole whirlwind of sometimes of a lot of things that you're juggling other than just the administration or probate application with the surrogate court.
Well, how do positions change over time once the dispute is underway? I think we've talked a little bit about how some things could change and complicate.
So positions change based on really the lifestyle of the party, the lifestyle of the person that wants a specific benefit. I've had certain clients where, unfortunately, I have to say, settle out for a lot less than what they are owed just because they need the money now. There's other clients that are willing to take it to the very end because they have a lot of money now and they don't really need this inheritance. It really matters what each party has in mind in terms of what they want out of the case rather than what is actually going to happen from the case. So positions change again specifically based on that party's lifestyle, because if the person has money to throw out on litigation, they'll say, to not only me but a lot of my other attorneys, have at it, do essentially whatever you want, just win. Other parties, and I've had a few clients like this, knock on wood, that they take a quarter or even less than half of what they're owed just because they need the money now. Bills are piling up. It's hard for them to essentially survive. So positions change based on the lifestyles of each person, essentially.
Well, what factors tend to influence whether a case resolves or continues to escalate?
A lot of the times it's the court. A lot of times it's the attorneys, but I will say that the court plays a much bigger role in conflict resolution than a lot of people may think. A lot of the times, or sometimes shall I say, when my client is the unreasonable one, I'll bring them to court for one of the appearances, and I want them to see how the judge is reacting to their position. And then after that court appearance, I can talk to my client and say, did you just see that? You can clearly now understand how the judge views not only you, but our position as being extremely, extremely unreasonable. I think we're better off suited settling for XYZ. So the court can really press the parties into a resolution by kind of hinting, or winking and winking as to how the case is going to be disposed of should it be led up to the judge. And I encourage a lot of attorneys to do this. If an attorney has an unruly or unreasonable client, bring them into the court. Say that the judge wants to see you so that they can see how the judge is reacting to their own position, and that'll put a lot of things into perspective. Once a client sees that the judge is not on board with what they want, they change their mind very quickly. Because I tell them it's either we do this and you settle for X, or we continue going through the litigation. You're going to owe us Y at the end, and then you're going to be left with Z, which is much less than my bill and what you would have originally gotten. So I encourage attorneys a lot of times, again, as I said, if you have a client that's not willing to be normal and reasonable, pull them into court.
That's some great advice, I think, because there's nothing like having a mirror held up to show you how you're behaving, right?
Yeah, and that's sometimes the hardest mirror to look at, is when the guy that or the woman that's telling you and judging your case is telling you that you're being unreasonable. That is one of the best kind of self-medicines there can possibly be in this field.
Well, Alan, this has been such a great conversation. I've learned a lot, and I know those listening, they're learning a lot as well. Thank you for joining us today to talk through this.
Absolutely, my pleasure, and I hope on to be for more episodes as well.
I hope so too. Well, that's it for today's episode of Obsessed with Success. To learn more about Morgan Legal Group and their work in estate and probate matters, visit morganlegalny.com. Thanks for listening, and don't forget to like, leave a review, and subscribe to the show so you don't miss the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.